I'm Anna Denton-Jones, and in today's session I want to talk about a recent redundancy case connected with somebody having had children, taken time off on maternity leave, and sex discrimination. What happened in the particular case is that there was a lady working in a particular company who had already taken one period of maternity leave off, and as is often the way, upon her return to work from that first period of maternity leave, she made a request to work flexibly, and an arrangement was made with her line manager that in respect of certain activities that needed to take place after 5 o'clock in the evening in relation to deleting certain things from the system, that they would do that, or she could do that from home, having done the preparatory work before she left to go and pick up her children. Time moves on and she is pregnant with her second child, and she needed to have time off to go to a medical appointment connected with that, and so confided in her line manager that that was the reason for her requesting that time off work. The line manager explains that this is what's going on to her line manager, and he exclaims with a certain number of expletives that she is pregnant. I won't repeat exactly what he said here, but it had the F word in it. Now, obviously that wasn't said in front of the employee, but she came to hear about the fact that that comment had been made at a later stage in a redundancy process. So it seems that the more senior line manager reneges on this agreement with the lady that she can do certain things from home, and starts putting pressure on her to sort of be more office bound, sort of reneging on the original working from home deal. And he then proposes a redundancy situation, suggesting that within her department they should reduce the number of headcount from 3 people down to 2, and that the posts that would exist going forward would be very much office based, would require this working from after 5 o'clock at night. So she at that point had to say, I'm out, because I can't comply with that. She then brings complaints of harassment connected with that comment that had been made, of unfair dismissal and sex discrimination, obviously arguing that the dismissal is tainted by the sex discrimination. And she was pretty much successful in both the tribunal and the Employment Appeal Tribunal. The tribunal found that the comment that had been made, even though it wasn't made to her, when she was told about it, was capable of amounting to direct sex discrimination and harassment. The EAT criticised the lower tribunal for not going on to the next stage of the test and talking about the effect that that had on her. So they sort of sent it back to them to deal with that. In terms of the reneging on the ability for her to work from home, that was found to be less favourable treatment in connection with her part-time status. And whilst the redundancy itself wasn't a sham, it was found to be a provision, a criteria or a practice that had an indirectly sex discriminatory effect on women, because women will find it harder to comply with the requirement to work after 5 o'clock, to work from the office, etc. So that put the employer in the position where they had to objectively justify that indirect sex discrimination, and that's where they fell down. The particular tribunal found that they couldn't justify it. They hadn't given any proper consideration to an alternative way of dealing with their requirements. Indeed, if it had worked fine for a couple of years for her to be doing these things from home of an evening, then why all of a sudden is there the change? So I think this case really does illustrate the care that needs to be taken when putting together redundancy exercises where there is a connection perhaps with somebody who has been working on a part-time basis, where a manager is pressing for change and saying that that no longer works. I think we need to be very careful to drill down into that assertion and understand what is going on there to make sure that it is not an example of sex discrimination. If anyone does have any queries, please email me. It's adenton@refreshinglawltd.co.uk.